matter was heard by your lordship, and your lordship directed that matter will appear on 15/5/2023 as for order, but it was not appeared.
Give the slip, give an intimation to your other side.
But by this time, in the determination is changed.
This is not our determination. Is this a residuary appeal?
Residuary appeal, my lord.
Residuary we can hear. Which year? Which year?
2018's matter renumbered at 2022.
Very good. We have the determination.
Oh, I see.
Up to 2020 we can.
But in the list, it's written up to 20.
Yes.
2020.
When was your matter
Up to
appeal
2020,
filed?
before that.
Sorry?
When was your appeal filed?
On 2018.
So we have the determination. It will appear.
Let this matter appear in the
It will
list.
appear. You inform your other side.
May I be permitted to mention one application in connection with first appeal? My lord, for correction, my lord, that matter, memorandum of understanding and memorandum of undertaking, Mr.
Yes, yes.
My lord, can kindly.
Where is your notice to the other?
I shall inform the other side, my lord.
You know, Judge.
My lord, may be permitted to
My lord,
mention,
when
my
my
lord,
lord,
just
keeping my lord. My lord, when,
So watch on the list. It will
my lord, I shall inform.
my lord, just before vacation, kindly remember, my lord, your lordship, you are pleased to pass an order modifying the degree of the learned code below.
Yes.
But there is some typographical mistake in the order, my lord. It will to be mentioned, it will appear on.
You follow the list, it will appear. You means
একটু তাড়াতাড়ি দেবেন, কারণ ডিগ্রি ড্রন হয়ে গেলে চলে গেলে আবার প্রবলেম হয়ে যাবে।
আমি তো ইচ্ছে 200 তুমি পরের লিস্টে যাবে তো শুধু হ্যাঁ হ্যাঁ সেটাকে single you must be having sufficient materials. কেউ শুধু মিউনিসিপ্যালিটি দিয়ে বসে দিয়েছে কোঅপারেটিভ পঞ্চায়েত সেক্রেটারি থেকে Yes, call the list.
One, appellate mother. Appearing as correction, my lord.
What is
Scan 2 of 2023. 22 is written.
কি বলবো বলো তো কত আর নিজেরা ইয়ে করে সালগুলো খালি ভুল হচ্ছে সালটা গাড়িটা দেখুন, ওকে ডেকে পাঠাও, কোথায় রূপমকে ডেকে পাঠাও। কি কি মিস্টেক হয়েছে এখানে? না তোমাদের জ্বালায় না মাটির জন্য FAT 22 or 2022
Can case হবে?
what is the error, sir?
My lord,
What is the
it has come up from the department, my lord, but can 2 of 2022 it is written, it will be 2023, my lord. The first can is 2022, but the second can is 2023, my lord.
by reason of a typographical error, by reason of a typographical error in the post title of the order dated 11th of May 2023, comma, one of the application, the number of one of the applications
One of the
by reason of type in the order dated eto, by reason of a typographical error in the order date in the post title of the order dated 11th May 2023, comma, the number of one of the applications has been incorporated as quote unquote একটা single inverted comma italics IA number stock can 2 of 2022 in place and instead of quote unquote IA number stock can 2 of 2023. Stock office is directed next paragraph to effect necessary correction. Stop. The other portion of the dot effect necessary correction. The other portions of the order shall remain unaltered.
Keep your place, my lord. No.
FAT নাম্বারটা কত 71 of 2013 তাহলে FAT টা
এটা মানে এটা ঠিক আছে, এটা 23 হবে। আর এটা মানে 13 হলে দরকার নেই। আমিও জানতাম যে এটাতে অসুবিধা হবে না।
by reason of typographical errors in the post title of the order stated second May 2023 and 15th May 2023. Separate orders. The number of the appeal has been incorporated as quote unquote FAT 71 of 2013 and quote unquote FAT 71 of 2022 in place and instead of, respectively, in place and instead of FAT number 71 of 2023. If necessary corrections in the order stated 2nd May 2023 and 15th May 2023. Other portions of the orders shall be made honor.
Lord, I appear for the respondents.
To that matter, where is your other side?
Mr. Rajnarayan Dotto is appearing for the appellant. The matter was heard by your lordship on several occasions before vacation. And it
So
was,
now, was it made part-heard?
it was made part-heard, I think.
Part-heard আছে?
It was made part-heard.
Mr. Talukdar, give a notice to him and come back. We shall take it up tomorrow.
As your lordship. Then would your lordship keep it on 9th?
9 তারিখ রেখেছে 9th.
I'll intimate Mr. Dotto.
Ask him to appear on 9th.
My lord. Only one thing for consideration of one proposal, lordship proposed. Lordship was not satisfied with other claims, but the security amount, regarding the refund of security amount. To that extent, my lord, lordship asked me to take instruction and Mr. Dotto to consider that. Only,
Any development? Then
and
we have
as per
to-
terms of the agreement, that is not refundable.
very on 9th we are not. তারিখ
Much obliged.
Sir, I appear for the respondent UCO Bank.
Let's
Any application pending?
no, my lord,
Any application?
no, my lord,
pending?
there is a direction of this honorable court, my lord, by which, my lord, banking ombudsman was appointed to banking ombudsman was appointed, my lord, to inquire into the matter, my lord. But there is a dispute between two centralized bank, my lord. One is UCO and other is, my lord, Central Bank of India. Now, my lord, I am the auction purchaser from the UCO Bank. Now, my lord, Central Bank says that
We are wanting to know, it has come under residuary application with a number of an application given. Has this application been disposed of?
No, my lord, all the
What-
things are pending. Is because presently the report has come and I believe my learned friend is trying to place that report before your lordship.
Where is that?
my report is with the record, my lord. We have obtained the certified copy. My report is with the record, my lord.
ওটা বের করে রেখে দেখি রিপোর্ট না এটা অ্যাপ্লিকেশন
Envelope.
when was that order passed? Asking
The order was passed on 29 July 2019.
29 July.
Yes, my lord.
2019. It's a long pending matter, my lord.
হ্যাঁ এটা রিপোর্ট হ্যাঁ ওটাই তো
May I hand over the copy of the order?
If it is on record, we shall
আরে এই
get
তো
it.
রেকর্ডে আছে
29
কোনো ইমপ্রুভ অর্ডার নেই
29 29 July.
হ্যাঁ হ্যাঁ এটা হ্যাঁ
এই ওইগুলো তুমি পেন ড্রাইভে পাবে, ওগুলো পেন ড্রাইভে পাঠাবে, আমরা দেখবো, নাম্বার চেক করবো, তারপর প্রিন্ট আউট হবে। রিপোর্টটা পেয়েছো? ও আচ্ছা, ঠিক। ইয়েস,
I'm not referring to kindly takes up the order
It has
first.
come for final hearing. It has
Yes.
come up for final.
This can be
hearing.
disposed of on the
Yes,
basis of the report filed by the ombudsman. Lord.
Take us to the ordered impugn.
Yes. Lord, at 156.
All the respondents are represented
Yes, yes.
or anybody is missing.
Yes. My lord, the private respondent is missing, I believe. Others are there. So far as the central bank is there,
They never
we are the
appeared.
UCO bank, and the private respondents from who has taken their property, actually, they are not being represented, I believe. Neither before the trial court nor before this division.
Then they are not. Yes, show us the ordered impugn.
Lord, 156 plat of the paper book.
Yes, please.
Petitioner 6, registration of the deed of conveyance in respect of an immovable property purchased by the petitioners in an sale conducted by UCO Bank under the provisions of Surface Act 2002.
Just one moment. Acha, আমি mostly- Self-response to- নিচে করতে হবে, সেটা তো সেটা তো exceptional হবে। CPC তে যদি Yes, yes.
Now let petitioner 6, registration of a deed of conveyance in respect of an immovable property purchased by the petitioners in a sale conducted by the UCO Bank under Surface Act 2002 and in alternative refund of purchase money. Then an advocate for the petitioner submits that the petitioners are interested in refund the purchase price as there is a dispute between UCO Bank and Central Bank over the property. He submits that the petitioners had participated
Petitioners are interested in
refund of money,
what was the quantum? How much?
about 15 lakhs.
15 lakhs. So you purchase the property in an open market sale conducted by the authorized
By the UCO
officer
Bank.
and handed over the money to the bank. All right. Then what is your grievance? What was
My
the
grievance was that my possession was handed over. And thereafter, there was another auction sale,
pertaining to the same property
same property by the Central Bank.
by the central bank?
Central
All
Bank. Now let's the person who,
You are still in possession?
no. I was dispossessed by the auction purchaser of Central Bank.
Central bank. All right.
I'm like, who is the actual owner? Where the property was actually mortgaged? That was to be determined. Lad. And that's why the banking ombudsman was engaged by the Supreme Court, lad, and factual finding has been given. And my ombudsman has recommended to refund the money in my favor.
Upon the deduction was upon UCO.
UCO Bank.
So why the writ petition was dismissed?
Bank did not, the single judge did not interfere into the dispute between the parties.
So was there any finding of fraud that the deed which was handed?
That is in fact the finding of the bank ombudsman.
That is the finding.
Without proper inquiry, the UCO Bank has
Now pertaining to that, any proceeding, criminal proceeding has been undertaken.
no. So far my knowledge goes no.
So the now the central bank has 13-4 steps were initiated by central bank also
Yes.
against the intending purchaser.
Yes.
Then what is your stand, sir? Return
My lord,
admitted
my lord,
the
if- no, my lord.
So far there were
My lord, let
just
my
one,
learned friend-
1 second just.
I will place my case.
No, we have not gone into.
Yes.
We are wanting to know.
No, my lord, so far as UCO Bank is concerned, they have conducted everything. In fact, they had the finding of the ombudsman is that the document that was given to UCO Bank is the original document of title of the property. The person who had deposited with the central bank he was duped by the person who sold the property to the mortgager of the property to UCO Bank, to the central bank. Now, so far as UCO Bank is concerned, they have taken proper steps. They have conducted search. They had taken possession after 13/4 and sold the property. Property was handed over to them. They have also received a vacant possession along with all the original documents. And subsequently, in the writ petition only, they were dispossessed by some person who said that they have purchased from central bank. Now, after quite some time, after a few months, after 4 months, now the question is that once that is there, what liability UCO Bank can have? Because UCO Bank has done everything in terms of the law. And there is nothing to show that UCO Bank has committed any fraud against the, so far as the writ petition is concerned. That is also the finding of the ombudsman.
Your argument is that let him fight out the case with those persons pertaining to the central bank.
Yes, my lord.
That is your story.
Yes, my lord.
Now, who is presently in possession?
Possession, I believe the writ petition will be dispossessed by those private respondents.
They are parties to the proceeding. Are
Sorry?
they parties?
Yes, my lord. That's why I said that they are not being represented. They are the private respondents. The last, I believe the last two respondents.
Is it a flat?
Yes, my lord.
They never represented before the.
No, my lord. As so far as my knowledge goes, my learned friend will be able to.
So, Mr. Jahan, their presence is necessary because today you are not interested in taking possession. You want the money back.
So in that circumstances, he ought to recover possession from private respondent number 2.
And for the central bank.
If the finding of the ombudsman is such that you disburse the loan taking a forged deed, then you have to correct.
There is no mention in my lord.
You are for the central bank, Mr.
I am for the central. Findings of the ombudsman, dispute of the title to the property between the borrowers of two banks require full judicial scrutiny by the civil courts. It is the findings of the ombudsman.
No, my lord. Page 6, if your lordship sees the report. Page 6 of the report.
Relegated to trying to relegate the parties to civil suit.
My lord, page 6 of the report. Paragraph Roman 3.
One Subroto Poddar.
Yes. They are their mortgage.
Yes.
Paragraph page 6 টা খুলুন রিপোর্টের। এটা পড়ুন, এখানে পরিষ্কার বলে দিয়েছে আপনাদের মর্টগেজের ফর্জ ডিড দিয়েছে।
Cascade facility নিয়ে আলাদা।
ওরা তো পজিশন চাইছে না, টাকাটা শুধু ফেরত।
আর টাকাটা
Possession charge. You are not wanting possession of the flat. You are only concerned with refund.
As recommended.
Then place the case. Then their presence is not required.
Not required. Now, let
No, no. Yes. Yes.
before I place them as the report, kindly takes up the order passed by this Honorable Court on 29 July 2019. The basis, my lord.
Page
29th July 2019.
the appeal.
No.
In the appeal.
Yes, in the appeal.
Yes.
From third paragraph, appellants are auction purchasers of a flat in a sale conducted by UCO Bank under Surface Act. They are in possession of that apartment. However, the registration of the document was not done. They came to this court seeking direction upon the UCO Bank to register the document in their favor. Alternatively, they prayed for refund of the amounts paid by them as purchase price in the sale conducted by the UCO Bank. In the writ petition, the central bank came out with a plea that the same security assets is the security offered to it, and the security interest that the Central Bank of India had over the property was also put to proceedings under Surface Act, and such property has been sold by the Central Bank of India as well. Thus, there could be competing claims in relation to the same flat or apartment. However, it is pointed out that the sale certificate issued by UCO Bank identifies a flat with a building number, but the sale certificate issued by the Central Bank of India does not carry any identification of the apartment on the basis of the number. UCO Bank and Central Bank are nationalized bank. They fall for adequate and appropriate control by the Reserve Bank of India. This is not one of these cases or those cases where the matter cannot be left at the stage in which it has now reached. The learned single judge has ordered the writ petition refusing relief claimed by the petitioners by way of refund of money. It has left the Central Bank of India and UCO Bank to proceed as it may find appropriate. We think that the facts of the case in hand requires deeper look to ensure that the confidence of those who buy such secured assets in auction by different banks are regulated as may be required. The very peculiar facts and circumstances of this case persuade us to direct an inquiry to be conducted into the transactions of the UCO Bank and Central Bank of India, which have led to this litigation and proceedings, which are carried by both these banks. Hence, we direct the inquiry to be conducted by the banking ombudsman appointed under Ombudsman Scheme 2006 or any succeeding scheme who has authority over the territory of the state of West Bengal. The banking ombudsman will be at liberty to exercise all powers in terms of ombudsman scheme as well as such further authority as may be necessary for due conclusion of the inquiry ordered hereby. We hereby authorize banking ombudsman to exercise such powers. We do so in exercise of writ jurisdiction. Banking ombudsman having jurisdiction of the state of West Bengal is required to conduct an inquiry following due procedure as to the notice, hearing, etc., also maintaining confidentially as may be found necessary and due. The inquiry shall be completed and report shall be filed, submitted before this Hon'ble Court on or before 15 November 2019. UCO Bank, Central Bank of India and the writ petition applicant are directed to mark their presence at the office of the ombudsman. Therefore, the procedure has been laid down by the court. Now, kindly look to the report filed by the ombudsman in detail. Kindly takes up page 2 of the inquiry.
But Mr. Jahan, your prayer in the writ petition was that either give me possession
Or
or
refund.
you refund the money. So in that case, the presence of those two persons is necessary.
But if they don't appear, we have served.
No, no, the thing is today, suppose we arrive at a conclusion that you are entitled to possession, then they have to be dispossessed. Because the appeal court in its order has protected the possession of the private respondent
Right.
in the meantime.
But I forego my prayer so far that the possession is concerned. But I do not want to. That's my instruction.
Not do so at this stage because your writ petition was that you either give me this or you give me this.
And if,
Now today, if you forego a part of your prayer, that is not within our domain. Furthermore, the appeal court, our coordinate bench has not listened to that argument of yours. What did the coordinate bench say? That in view of this factor, in fact, the coordinate bench has taken up on it the responsibility which ought to have been taken by the civil court as directed by the writ court. So now, Mr. Jahan, their presence would be necessary. Because suppose we hold that the sale was conducted in the appropriate manner by the UCO, then the question remains, what can be your relief?
that part has been gone into by the ombudsman.
That has been gone into that. Is
And
your
that factual
context.
finding has not been challenged by either of the bank till today. Now this is holding the field.
Do one thing which fix the matter. You give a notice to those. If they do not.
That I can do. That I can always.
Ashok, pursuant, আচ্ছা রূপম তুমি একটু যখন লিখবে নাম্বারটা দেখে নেবে তো একদম এম্বারেসিং হয়ে যাবে বলো প্রত্যেকবার
I'm not Jahan, but I'm Shamim Ahmed.
That was an error at the commencement of this portion of the working culture. Pursuant to the earlier order passed by coordinate bench of this court on 29th of July 2019. 29th of July 2019, a report has already been filed by the Banking Ombudsman, Kolkata. Stop. We have heard Mr. Ahmed, learned advocate, appearing for the appellant, Mr. Chakraborty, learned advocate, appearing for Central Bank of India, and Mr.
Rai.
And Mr. Rai, learned advocate, appearing for
UCO Bank, my lord.
appearing for UCO Bank. Today, however, no one appears on behalf of the respondent numbers, private respondent numbers.
So 13 and 14, my lord.
13 and 14.
Yes, my lord.
13 and 14, whose presence is required for adjudication of the matter.
Oh, acha.
In view thereof, list this matter for further consideration.
My lord, with your lordship's liberty, I have prepared a note. No, my, yes, please.
Adjudication in view thereof, list the matter for final hearing in the daily supplementary list of this court on they are in Calcutta, na? This private.
Yes, my lord. They are in possession of the
daily supplementary list of this court on 14th of June. 14th of June. Stop. The appellants are directed to immediately intimate this order to the said private respondents and to affirm an affidavit of service on the returnable date. It is made clear that in the event the private respondents do not appear in spite of such notice, this court would be constrained to proceed with the matter ex parte against them.
My lord, with your lordship's kind leave, Well, I note having prepared, I will also be giving to them. Let this note be in respect of the report of the ombudsman. Well, that will help your lordship to, so far as
ওই
you provide.
বলেছো না মিস্টার রায় লার্নেড অ্যাডভোকেট তার সাথে
Again,
একটা
Odeta,
let the documents comma as submitted comma by Mr. Roy be kept on record. Stop. Copies of the same have already been handed over to Mr. Ahmed and Mr. Chakra.
I'm going to work.
To affirm an affidavit of service on that.
Grateful, your lordship.
But I shall serve in the address given in the cost title as well as the address of the auction purchase property in both.
It will be better. But will that be possible within 14?
Yes, yes.
Get it?
Grateful.
That would be constant to proceed ex parte against them না বলে বলে in their absence, ex parte against them না বলে in their absence.
In their absence.
In this matter, I am appearing on behalf of appellant, my lord. But respondent LICI did not come, my
Come tomorrow. No one is there.
lord. Day after tomorrow.
Day after tomorrow. ঠিক আছে. Day after tomorrow. Give a notice to your friend. Give a notice to your friend.
Well, I am appearing for the respondent.
Lord, I appear for the State Bank of India, my lord.
In this matter, Mr. Mukesh Kumar Gupta is for the appellant, my lord. He is suffering from viral fever for last 2 days, my lord. Your lordship kindly adjourn for fortnight, my lord. Mukesh Kumar Gupta is suffering from viral fever.
What is the issue? What is the issue? Just, Mr. We shall, what is the issue? Tell us.
My lord,
You are the appellant.
no, my lord, I am the respondent bank.
Oh, he is the appellant.
My lord, Mukesh Gupta is for the appellant.
Okay, we have heard it.
Yes, tell us now, what is the story?
My lord, under SURFACI Act, my lord, a sale was confirmed by the bank. My lord, that was challenged by the writ petitioner, my lord, by way of a writ petition. My lord, the writ petition was dismissed, saying that your remedy lies before the DRT. My lord, that has been challenged before your lordship in appeal.
Oh, deed was not executed.
My lord,
After
deed
sale
was
certificate.
yes, my lord, the entire
Where
sale,
is
my
the
lord,
requirement, Mr. Rai?
my lord,
Sale certificate, if issued under the SURFACI Act, is there any necessity
no,
for
no,
it?
no, no, my lord, no. It
Why
was,
do you
there
say
was,
so?
my lord, I say so, my lord, because of the recent two judgments, my lord, of the Honorable Supreme Court, which have, my lord, clarified, my lord, SJP, my lord, I don't have that judgment today. My lord,
Clarified what? There was a Madras High Court judgment at the initial stage.
now, my lord,
That sale certificate is not required to be registered even.
yes, my lord, that has not been considered, but my lord, Honorable Supreme Court, my lord, has independently held, my lord, going on certain provisions of the Registration Act, saying that when a sale certificate is issued, my lord, the only requirement,
Section 47A, that is a separate issue.
no, my
Whether
lord, in this case also, my lord, the Supreme Court has held that the only requirement is that the authorized officer will send a copy of the sale certificate to the registering authority, who will keep it in the file.
Hmm.
That's all. My lord, the registration of the sale deed or execution of a sale deed is not required.
he was the judge.
Judgment.
My lord, I shall supply, my lord. Today I don't have, my lord, because that was not the issue here.
Give it to our officer.
My lord, I shall.
Give the
Because there are
citation.
two, my lord, both of Justice M.R. Shah, my lord, and one, my lord, considering these two, my lord, a three-judge bench judgment of the Honorable Supreme Court, three at a time. My lord, holding the same, my lord, one is SJP, my lord, if your lordship kindly permits me, my lord, I shall indicate that, my lord.
No, Mr. Rai, you do one thing. You give the citation of those three judgments. Can you give it today?
Yes, my lord, I can do.
So you give it, hand it over to my court officer. Only you can give the citation, not the copy of the judgment, not required. Do you have it? That special bench judgment, you have it?
My lord, I think, my lord,
Lord, I'm missing it, Lord. I have it in my chamber, Lord. I shall give it to your Lordship.
All right, এটাকে কবে আছে কত তারিখ আছে? Keep it on 19th. 19th?
19th.
Yes, Mr.
19th.
You wanted 2 weeks.
Lord, instead of 19th, Lord, any other day, Lord, either before or after 19th, Lord, I already have a matter.
20th?
No.
20th? 20 তারিখ রেখে দিও তা।
Lord, the first one which I have right now, my Lord, it is SJP Impex Private Limited versus Assistant General Manager and Authorized Officer, Canara Bank. Lord, this is a 5th of January 2021
No,
by the Honorable Supreme Court, Lord, a 3-judge bench.
3-judge bench of Supreme Court.
Sanjay Kishan call.
Give us the citation.
Lord, citation, Lord, I don't have. Lord,
Name.
Lord, it is SJP, Lord.
SJP.
SJP. ESJAY PWE. SJP Impex Private Limited versus Assistant General Manager and Authorized Officer, Canara Bank.
But there was a division bench judgment of Belfast.
Lord, this is Supreme Court.
This is of which year?
5th January 2021.
If All right. You give us the citation today.
Yes.
At any
Lord, I
time.
shall give a printout of this, Lord. I have it. Since I have it,
Print out not required. You give us citation. Finish.
I have the Manu citation, Lord.
Money from your pocket.
This is Manu Patra citation I have, but I do not know, Lord, whether.
Very good. You if you ascertain that this is give the citation to my.
Very well.
If not possible today, give it tomorrow. Yes, next.
না, এটা আপনার জন্য নয়, এই ম্যাটারে নয়। Grateful.
Seven.
Well, in this matter, Mr. Bari is appealing praying for only 1 day accommodation for his. Only 1 day. Kindly take it.
Madam, keep us engaged. We have only 9 matters in the list.
Well, kindly take it tomorrow, my lord.
What is the matter, Mr. Deva? All right, tomorrow. It's an assigned matter to us.
Yes. Assigned matter.
Education matter. Mr. Badi is appearing. Education. What is the issue?
Page 133, madam. Long judgment. But by
ঠিক আছে, come tomorrow. Mr. Devrai, kindly come tomorrow. Is it ready for hearing or any application is pending?
application stage. Application stage, first stage.
So you have exchanged your affidavits in this?
No. First
Was
stage.
never heard.
Never. This is the first time.
The file টা দাও তো দেখি।
This is the first time, madam.
First time আমাদের কাছে assign করে
Initially, it was, Lord, based on the Justice Origin Banerjee. Justice Banerjee. Thereafter release. চিন্তা বলবো আপনাদের।
চলবে না। The court decides the court will function what people need. You are not concerned with that. You are concerned with that. সেটা হচ্ছে inform করতে
Very long judgment, page 133.
No, this is a municipality matter, not an education matter. Municipal service.
Municipal service.
Service matter.
That is why Justice Banerjee has taken up the matter initially, that is the release due to personal ground.
ঠিক আছে। Property services. Challenging order of termination.
Contextual service.
Any private respondent is there?
No,
No, ma'am.
Is for the, you are appearing for the municipality,
no, state of West Bengal.
you are state. Issue is as regards termination of our service under the municipality. So have you served upon the municipality?
Yes, my lord, we are served.
Served?
Yes.
Who is appearing? Municipality?
Now.
Sandipon Banerjee.
Ondipon
Pinaki
Banerjee
Babu.
appearing.
Huh?
for the-
Sandipon Banerjee, 3, 4 and
Ondipon
5.
Banerjee.
My lord, kindly,
4 and 5. It Howrah Municipal Corporation.
Howrah.
তো কালকে কি করে শুনবো আবার একজন করতে হবে। থাকুক না হলে কি একজন করে কেউ মামলা দিয়ে দিচ্ছে। All right, come tomorrow. And from the records, it appears that Sandipon Banerjee
Banerjee,
appeared for HMC.
Yes, my lord.
Give a notice to him today itself.
Okay.
All right, come back tomorrow. Yes.
Tomorrow.
তো এর জন্য।
Lordship, I am for the respondent number 5 to 7. My senior is on her legs. Kindly give me a short pass over.
Last occasion also, my lord, they took time.
My lord, give a short pass over.
May I
please.
proceed, my lord? In the meantime, he may join.
Yes, proceed.
Yes, proceed.
Yes. State is not required.
State appeared, my lord.
State appeared.
And Bruce Tony.
Mr. Moitro, his presence is required. State.
Not that, my lord. Not very much.
All right, let us hear what
My
is
lord.
the matter.
My lord.
Thereafter, if required, we shall. Yes.
My lord, the Unnagar Rishra Water Transport Passengers Welfare Association is a petitioner before your lordship. My lord, there was a ferry service from Konnagar to Panihati and my lord, to and fro. But in the year 2012, precisely, my lord, on 10th
7 July 2012. License agreement.
my lord, for 10 years with the Surface Transport Corporation. in the year 2012, my lord, kindly take a note of it, 10/5/2012 for 10 years. My lord, it was due to expire, my lord, on 2022.
2022.
Yes, 2022. My lord, from the date of execution of the agreement till 2015, the petitioner, the Welfare Transfer Association, was operating the service smoothly. Now, in the year 2015, Konnagar municipality jumped over us in order to forcibly encroach the service of that, my lord, ferry service. We had to move this honorable court. But this honorable court granted protection not to interfere with my transport service. And my lord, Konnagar municipality was very much party. The then chairman of the Konnagar municipality was party to the writ petition. Despite that, my lord, there was interference. Then we came out with an application for contempt for violation of the interim order as granted by this court, protecting my service. The then, my lord, chairman gave an undertaking that we shall not interfere with. Even then, my lord, an order had to be passed by this honorable court directing the district magistrate and the superintendent of police to hand over the possession of the ferry service. But in the year 2021, with the intervention of the district magistrate and the superintendent of police, it was handed over. Kindly appreciate, my lord, 10 years duration of the agreement. 2015 to 2021, we are totally forcibly ousted because of the intervention of the Konnagar municipality. I shall show all the documents. And only when this court directed SP and district magistrate to take steps so that we can resume the service, then and then only we again started to resume the ferry service.
That was when done. Your 2015 year work was interfered.
Yes.
You approached the writ court.
Yes.
Writ court said, gave you an interim protection.
Yes.
Undertaking given by Konnagar that you will be allowed to continue.
That
was a violation, that alleging violation you came.
My lord.
Now the contempt, exercising contempt jurisdiction, court said that return the service.
Yes.
When was that return made? 2021.
April 21.
Very good. April 21, you started functioning.
What the resuming, my lord, service?
You resumed.
Yes.
April 21, you resumed.
Yes.
Now thereafter.
Kindly appreciate from 10 years, lease period, license period was 10 years.
So we understand it was till 2022.
Yes.
10 years license period.
My lord.
Now after the contempt order was passed, you were given back possession.
My lord.
Now then what happened?
Then, my lord, we made representation before the
for extension of the lease period.
Fine.
Now that
they kept quiet.
But in the meantime, there was an auction. Another person came.
I am coming. No auction, nothing of that kind. Thereafter, what happened, my lord? One fine morning, the service that, my lord, the ferry service was given to the Konnagar municipality. And Konnagar municipality
gave it. Who gave it?
Service Transport Corporation. Hon'ble municipality, in his turn, appointed
another person
without any notice, without any intimation, and the person who was given the charge of the service is blacklisted.
That
blacklisted.
Who
was given the chain, my lord, this service. Now, my lord, peculiar feature of this case.
No,
is
Mr.
this.
Moitra, what interim protection you want?
My lord, I am
The
asking,
petition has not been disposed of.
my lord, I am praying for my lord status quo ante. Under these circumstances, my lord, I know status quo ante, unless I can make out a very strong case,
Oh, that
You-
person is not here, Mr.
my lord, that
Moitra.
person is not required. I am challenging the decision-making process. And that too, how?
That the court will consider,
Well,
Mr.
kindly appreciate, my lord, how? This writ petition,
How can we prejudge the issue, Mr. Moitro? Your contention, you have weighty grounds. You say that on court's intervention, I was given back possession in 2021.
yes,
After that, I made a representation to them that since my license is expiring on 2022, you extend it for 6 years.
no, I am not on that, my lord. I am
No,
making
Mr.
this submission, my
Moitro,
lord.
our query, our subject to what you
My
say, our query is today municipality has taken over possession from you.
Yes,
That fact was brought to the notice of the learned single judge by you. Court said, all right, I shall decide the dispute and I shall pass necessary order. At this stage, can the appeal court prejudge what will be decision of the writ court, Mr. Moitro? Kindly come to page 162.
my lord, I have seen, my lord, the order passed by the learned. My lord, I am making this submission.
Instead of taking a further, because good, bad, indifferent, today your submission if you make, we have to deal with it.
My lord,
So that will be maybe in contrary, will be prejudicial to you in the writ petition.
my lord,
Today,
if,
if Mr.
my
Moitro
lord, I am
wants-
submitting this way, my lord. If on the face of it, my lord, my writ petition was before granting.
Merited গেলে তো উনি যে আর্গুমেন্টটা করবেন তো সে তো আমাদের মেরিটে গিয়ে ডিসাইড।
My lord, there are some, my lord, another feature of this case. This,
Mr. Moitro, we are just wanting you to give a second thought.
my lord,
Second thought, you are wanting status quo ante. Writ court said that yes, there are weighty submissions made before me. I will consider that. But since the license period has expired,
but I was continuing.
since the license period has expired and you are alleging that the municipality has given it to a blacklisted person.
But municipality has got any authority. I am asking to my kindly appreciate two aspects. This writ
No,
petition,
no, we will we will listen to your contention.
my lord,
But Mr. Moitro,
my lord, I quite see to it, my lord. What
yeah,
fell
you
from my lord,
give a second thought and tell.
my lord, what fell from my lord, is quite rational, and that is the pragmatic approach of the court. But question is, my lord, this writ petition was affirmed on 3rd, before it was handed over. And my lord, copy was sent to all the respondents, including the corporation, municipality. This writ petition was filed on 6th. But it could not be moved because of, during that period, consecutive, my lord, the sad demise of the stalwarts of our bar and court were not functioning. On 10th, they gave the position. So, my lord, doctrine of dependence is quite squarely applicable.
But you have to make him a party, Mr. Moitro.
But when
Good,
writ petition was moved, he was not there.
He was not there.
Yes. Now, but in one judgment, Supreme Court has held that yes, he need not be made a party because in the grant of the license, it was clearly stated it will abide by the result of the writ petition. My doctrine of dependence. Now, doctrine of dependence, my lord, is also applicable in this case. Since, my lord, before it was granted to other person, writ petition was affirmed and copy was served. And due to some unavoidable circumstances, my lord, we could not move the writ petition.
All right, place your case.
My lord, this is one aspect. Secondly, my lord, whether Transport Corporation, West Bengal Surface Transport Corporation, on their own gave it to the corporation municipality. Charge of that ferry was given to the West Bengal Surface Transport Corporation. There must be a notification then. Some person,
No, these points are open to you, Mr. Moitra.
Yes.
in the meantime,
No, what further prejudice will be caused to you? Today, there is no further prejudice. Your contention is you have been illegally ousted.
yes,
So if we if we consider the question of status quo ante, we have to go into those facts.
naturally. My lord,
So if we go into that fact after hearing you, either in your favor or against you,
only prima facie, your
prima
lordship will
facie
consider.
jurisdiction, Mr. Moitro, at this stage, status quo ante may be a difficult question.
But my lord, if on the face of it appears, my lord, kindly appreciate, my lord, two points. Firstly, my lord, doctrine of legitimate expect.
His is not the license is not there. We would have confided with you had there been subsisting agreement.
Now, subsisting agreement, had I been, my lord, I will be very strong footing.
We will be, it is your choice if you say that you do not proceed with the appeal. The appeal will be.
Well, may I make one humble submission?
Yes.
Your lordship can hear out the writ petition also.
সেটা করা উচিত হবে।
Your lordship can hear out the writ petition.
That won't be.
If my lord interim order virtually disposes of the writ petition, your lordship can do it. Well, number of occasions, my lord, division bench has done.
Then we have to call for affidavits from them.
Yes,
Petition becomes
yes.
infrastructure.
In the meantime, kindly protect to some extent.
That will not be.
We should be giving him
The
chance.
single judge will be considering, exercising her decision.
But my lord, kindly
He will be
appreciate.
usurping the jurisdiction.
Yes.
But kindly appreciate, my lord.
We appreciate that. We appreciate your contention. That license agreement was with State Transport Corporation. How come the municipality came into the picture? You have grounds to argue. But
And
the
even
thing
after
is
the
that
expiry, I was continuing.
I
was
think,
continuing.
it will be better, Mr. Moitro, if you withdraw the appeal and fight it out before the.
My lord, your lordship knows, my lord, to have the writ petition hard, it will be an Herculean task.
No, not an hard.
It is a Herculean task. My lords have own experience. A writ petition of
Say that
We
the
can say
writ petition will be expeditious.
Expeditiously hard.
We will request the court.
Really.
give some indication, my lord, within the period. Or my lord, your lordship only record my submission, the suffering, the grievance I am suffering.
Yes.
And that
আমাদের তো বলতে হবে there is no scope or we are not satisfied that here status quo ante is to be given.
no, my submission
Once we
regarding my sufferance.
Once
Once
we
you
record your
clear-
submission, we have to deal with your submission.
Status quo.
No, without dealing.
You
Status
are
quo.
asking us to consider an issue. You are asking us that you are.
No, when your lordship remanded back the case for writ court,
The appeal and fight it out.
Withdraw এবং উনি বললেন যে
my lord, if I withdraw, my lord, if I withdraw, then my lord, it could not be hard. Your lordship on this order dispose of the application and appeal. That it is a matter to be heard by the
That the court has said. I
honorable
will-
single judge, and regard being had to the urgency of this matter.
Have you exchanged your affidavits in the?
No, nothing.
My lord, our affidavits are ready, my lord. Only,
Affidavits are ready.
yes, affidavits are ready, my lord, from our side at least. My lord, since this appeal was preferred, my lord, it has not been exchanged as of yet.
there is no, there hardly any scope to stop.
এইটা আমরা under-
Expeditious এর জন্য দাঁড়িয়েছে। এটাই
Or your lordship can, my lord, record your desire to have the matter heard expeditiously by the sir.
But you have to withdraw because page 163, your interim order has been refused.
Yes,
You
yes.
have to withdraw the appeal, no, Mr. Moitra. I told this, we told this to you prior to the vacation.
No, on that occasion, your lordship asked me whether without presence of.
Once we say something, your
My
other.
lord, I
side
am
will
thinking,
take
my lord,
the-
if I withdraw the appeal, whether your lordship can pass any order.
We will record your withdrawal and we will, however, say that the court below will expeditiously hear it out. We shall extend the time for filing the opposition. And
Grateful, my lord.
And if you indicate preferably.
Mr. Mitchell and the advocate upon instruction submits that the appellant does not want to proceed with the matter.
proceed with the
Proceed with the appeal.
in view thereof, the appeal and the connected application are dismissed as withdrawn. The learned advocate appearing for the municipality.
Yes.
You have prepared your opposition.
Not yet. Because there is already ballot in the meantime, they prefer the appeal.
কি বললে তুমি? না, is dismissed as withdrawn. বলেছো তো, appeal and dismissed as withdrawn. The learned advocates appearing for the municipality and the Surface Transport Corporation.
West Bengal Service Transport Corporation.
West Bengal
Surface Transport Corporation.
Surface Transport Corporation. Oh, state reserve. Are directed to file their affidavit in opposition to the writ petition within a period of 2 weeks from date. Stop. Reply. The appellants would be at liberty to file a reply. File replies within a week thereafter. Stop. We request the learned single judge to, I know.
Scope to pass any.
Reject করে দিতে হবে তাহলে। ওটা তো রিজেক্ট করে দিচ্ছি না। অ্যাপিলে অর্ডার পাস হয়ে যাচ্ছে। আচ্ছা, এরম লেখ Mr. Moitro, learned senior advocate appearing for the appellants submits, upon instruction, that the appellants do not want to আগেরটা কি লিখেছে মিস্টার মৈত্র? হ্যাঁ, আগেরটা যেটা সাবমিটস বলেছো। Mr. Moitro, learned senior advocate appearing for the appellant submits upon instruction that the appellants do not want to do. Mr. Moitro, learned senior appearing for the appellants prays for do not want to. Mr. Moitro, learned senior advocate appearing for the appellants submits upon instruction that the appellants do not want to proceed with the present appeal and the application. In view thereof, the appeal and the connected application are dismissed as withdrawn. You are making difficult for us to overcome that status quo ante. ওটা কেটে দাও। On the prayer of Mr. Moitro, learned advocate, senior advocate appearing for the appellants, the appeal and the application are dismissed as withdrawn. Mr. Moitro, however, submits that the writ petition requires expeditious disposal. And Mr. Moitro, however, submits that বলতেও পারো না, এপ্রিলে ওরা অ্যাপিল ফাইল করে দিয়ে চলে এসছে, আর কিছু বলে
Prays for expeditious disposal of the.
মৈত্র হাইবার, সেটা তো রিট কোর্টে যাবে না আমাদের কাছে। dismissed as withdrawn বলেছো তো, stop, next দেখো। We have been informed by the learned advocates appearing for the Hon'ble municipality and the
West Bengal Surface Transport Corporation, my lord.
learned advocates appearing for the Hon'ble municipality and the West Bengal
Surface Transport Corporation.
Press for extension of time to file the affidavits in opposition to the writ petition. Stop. Let such affidavits in opposition be filed within 2 weeks from date. Replies thereto, if any, be filed within a week thereafter. The appellants would be at liberty to pray for expeditious disposal of the writ petition after exchange of affidavits.
Leave it on us, my lord. Kindly, my lord. Only desire. Your lordship, record your lordship's desire. This petition may be hard
You
expedient.
have to go then into the appeal, Mr. You
No, my lord,
complete
only
the service
this
and
can
makes-
be recorded, my lord. Regarding had to the urgency of the matter, we desire that matter to be heard expeditiously. This can be, my lord, passed. Otherwise, my lord, it will not be heard. I can assure your lordship. This lordship can record. It is not a direction. Your lordship desire.
কি লিখেছো, Mr. Reply thereto, if any, we there. We request the learned single judge. We request the learned single judge to dispose of the writ petition expeditiously
My lord,
after the affidavits are exchanged by the parties.
Extremely grateful, my lord. Obliged to.
For item 9, my lord, I appear for the appellant.
My lord, I am for the respondent number 2.
Engaged.
I'm sorry, my lord.
You have been engaged later on.
No, I was there, my lord. Last time, my lord, I could not appear, my lord.
Oh.
When Mr. Gupta was addressing the court, my lord, on that day, my lord, I could not appear.
They filed the yes.
My lord, I am for the respondent number 2. Actually, advocate on record, Deepraj Basu and Choyan Banerjee is on the way. He stuck in another
All
court.
right, let him start.
Okay, my lord.
But only one thing, where the last day's order, my lord, we could not find it from the portal.
What order we passed?
But I don't exactly remember. Only thing I wanted to know whether Mr. Gupta had concluded or not. I am ready.
It so happened, Mr. Dotto, you were not there.
Yeah, I was not
And,
there.
Mr. I think
Basu,
Mr.
Basu.
Basu was appeared.
Yes.
So there were plenty of facts involved.
Yeah.
So we told that let us hear what are the factual issues involved. On that basis, he started. Mr. Gupta concluded his arguments.
Very.
So then we asked Mr. Basu that what remains.
Very.
He said that I will place further facts to law. Then it in fact is a re-argument, which is no? Mr. Lokhi Gupta is here.
My lord, I am not aware with the facts and okay, he is coming. He is on the way, my lord.
Mr. Gupta is here.
On the way.
Last day we said we will appear as for orders.
Yes,
This is the order. এটা সার্ভার করনি নাকি? সার্ভার হয়েছে তো? It has been served. Yes, Mr. Dutt.
Well, only Millard, for recollection of facts, Millard. Millard, a consortium was awarded a contract. I am, Millard, one of the parties to that consortium. I am P.K. Thakur. The other party to the consortium is ION Enterprises. Where the work was given, Millard, for which, Millard, we had to, Millard, excavate or dig, Millard, materials from the surface.
Yes.
Now, Millard, in course of the work, Millard, we had encountered, both the consortium partners had encountered.
He's here.
He on his way, my lord. He's on his way, my lord.
Oh, he has come.
Yes.
Now, Millard, we had encountered.
Mr. Dutt, just
Yes,
give us 2
yes,
minutes.
yes, yes.
That's fine.
Arbitration clause আছে additional jointly assigned. What is it?
Yes, Mr.
Now, Millard, while executing the work, both the consortium partners, Millard, had encountered rocks, which according to us was not part of the contract. Rock cutting was not part of the contract. Now, the grievance before my lords are that in so far as rock cutting by my consortium partner, the other partner is concerned, that has been acknowledged by the respondent.
Yes,
And
that was the issue.
yes,
But this fact was not told to us, that rock cutting was not a part of the.
yes. I'll demonstrate that.
Yes. So for that rock cutting, this your consortium partner was given the benefits, but you were deprived.
Yes,
This is your content.
yes. This is this short facts where the learned single judge felt that the writ petition cannot be entertained because it involves disputed questions of fact. Therefore, my lord, the writ petition was dismissed, and my lord, we are before the Honorable Division Bench today. Now, my lord, the first thing is, my lord, please, 4 or 5 pages, my lord, I'll not trouble your lordship with much. Please take page 96 and 106 of the stay application. This defines, page 96, defines the soil characteristics of the area, where the contract was to be executed.
Yes.
But this is the soil characteristics, which clause 7.3. The site is generally filled with heterogeneous slag, stroke plant waste, etc. of varying thickness. The size, shape, and density of such fill may vary up to an extent which is generally common for steel plant waste. The thickness of the slag may extend up to 25 meters from the terrace line. Below this slag, there exists cohesive to semi-cohesive virgin soil deposit of various thicknesses overlying weathered rock layer, predominantly of sandstone variety. Geotechnical specification for slag-filled areas is enclosed in Annexure 3. This Annexure 3, your lordship would find at page 106. 106 says the same thing. Clause number 1. But before clause number 1 is, the geotechnical specification furnished herein shall be considered by all the bidders for civil foundation, etc. Then clause number 1 is subsurface, which is same as page 96. But the
What you are arguing on that?
my argument is, this is the soil characteristics which was made known to the bidders at the time when
Contract was entered in.
when bids were submitted. Now, my lord, I had started, or the consortium had started executing the work. My lord, we are, my lord, on the issue, my lord, whether rock cutting was part of it and how much I have executed. First part is how much I have executed, my lord. There is a document on record which your lordship will find, my lord, from page 415. Please take page 400.
The rock cutting was undertaken by you.
Yes, no dispute on that.
Fact.
No dispute on that.
So, but you say that the soil characteristics details will show that specifically that rock cutting was not involved.
Yes. That my lord, the interpretation your lordship will get, my lord.
So this argument is for going out of the arbitration clause which has been incorporated in the agreement.
My lord, arbitration clause, I think my client had invoked on some other issue, not on this issue. My lord, on that, my lord, I will also, my lord, satisfy your lordship, my lord, these arbitration clauses are, my lord, no absolute bar, my lord, for adjudication by this court, number 1. And number 2, since the Honorable Single Judge had dismissed the writ petition on the ground that disputed questions of fact cannot be gone into in the writ jurisdiction, but there are several decisions which says that yes, it can be gone into. Unless it requires, my lord, adducing oral evidence or anything of that sort, that is the absolute bar.
Yes.
Now, first is, my lord, page 415, where this is a map which has been signed by both the parties.
450.
Oh, this is a big page. Or 1.5. Yes,
Yeah.
yes. Yes.
Which one you are showing?
But please take note the extreme right hand side.
Of the first page?
I think this is only one page. I think it's one page only.
Yes, extreme right hand side.
Right hand side, mirror on at the top, where there's a chart or a box where lordship finds mirror reservoir number 2. Yes. My lord has found, my lord, the reservoir number 2 area.
1.
First is 2, then is 1. It should be the other way around. Anyway, whatever is here is here.
Yes, what you are showing?
Now, reservoir number 2 area, it says average top rock levels is 113.875. Average post-rock level is 110.775. Therefore, my lord, there is a calculation which comes to 56,783.436 cubic meters. Similarly, for reservoir number 2, my lord, it is 10,949 and odd cubic meters. Now, please come to the bottom of that chart. Please take me at the bottom of that page. Your lordship will find me several signatures. These are the signatures of all the parties. First signature is of the DGM of Mekong. Second is DGM of ISCO, that is the respondent. And the third, again, a consultant and the site engineer.
So this map is annexed to what?
To my writ petition.
No, no. You had the bidder.
Yes.
After this map was prior to your.
No, this is during execution of the work. During execution of the work, to demonstrate to what extent, my lord, rock cutting was taken up or required. Now, this is, my lord, an admitted document. There is no dispute to that. And, my lord, signed by various persons, including, my lord, the appropriate authority, my lord, of the respondent or the appropriate officer of the respondent.
So the fact that there was excavation is admitted.
Is admitted. There is no dispute on that. Now, please take, my lord, page 433 and 434.
Now you are taking us to
page 433 and 434 on the aspect that there is no dispute that rock cutting was undertaken.
Yes.
This is dated 30th of January 2015. Or if your lordship will kindly take 434 first, because 434 is at the earlier point of time. I'm sorry, Milord. Please take 434 first. But this is in respect of the other consortium part. IOM.
Other member of the consortium.
Other member of the consortium, which says that we approve the change order of the work specified in the change proposal and agreed to adjust the contract price as per the terms and conditions of the contract. One title of change, please take serial number 5. Authorized price, extra work for intake work, plant and so system, package number 20. Then under that, II, rock cutting and disposal at WTP area, rupees, etc. So. So revised contract value comes to 109 crores. Now, this is how, my lord, my consortium partner is being treated. Now, how I am being treated is at page 433, which gives rise to the present writ petition. Kindly take me the first paragraph. Please refer the following extra claims raised by Messrs. P.K. Thakur. Under that, please take B. I'm sorry, yes, B. A is additional excavation work. B is rock cutting and disposal during excavation of the works reservoir. Well, we are concerned about B, we are not concerned about A and C. Now, please take me the fourth last line of that page. However, your extra claim regarding rock cutting and disposal during excavation of the works reservoir has not been made tenable by Mecon. Therefore, my lord, number one is the fact that I have executed the work is not under denial. Number two is the fact that it is an extra work. My lord, they themselves, my lord, call it an extra work, both at page 433 as well as 434. The third aspect of the matter is that if both the consortium partners have undertaken rock cutting, which is not in dispute, and both are extra work, well, whether, my lord, payment can be made to one of the consortium partners and denied to the other consortium partner. This is the short point, my lord, for your lordship's consideration. There is no dispute that I have done the work. There is no dispute in regard to the quantum also. Now, my lord, I make an averment to this effect, but at paragraph 11 of the stay application. Page 9, para 11. That the petitioner state that the change work, additional work of rock cutting to the extent of so and so was not disclosed in the NIT and or the contract agreement, but carrying out of such work was extremely essential for the purpose of giving effective execution and completion of the work under the tender as a whole. The petitioners in consortium with the pro forma defendant have kept on carrying on the entire work, which is the changed additional in nature, and the project consultant as well as the competent authority of sale have extensively certified about the execution, commission, and volume of such work being carried out by the petitioners. This is my averment. Kindly see how this has been dealt with in the affidavit in opposition, para 28.
Para?
28 of the affidavit in opposition. Para 28, my lord, your lordship will find at page 7 of the AO. With reference to para 11 and 12 of the application, it is denied that there was any change of work or any additional work as alleged or at all. The contract cutting was included, the rock cutting was included in the scope of the contract, and I deny that there was any requirement to specifically disclose the same in the NIT or the contract. The contractor was required to get acquainted with the site conditions and deploy suitable machinery for the purpose of carrying out the work. The work carried out, this part I lay emphasis, the work carried out by the contractor was essential for the purpose of effective execution and completion of the work. And I deny that it can be termed as an extra work. As alleged or at all, the fact that the petitioners have contemporaneously understood that such work was not beyond the scope of work and was not an extra work would be evident from the fact that there has never been any contemporaneous correspondence from the end of the contractor intimating the respondent of the said work purporting to be an extra work beyond the scope of the contract or claiming any extra amount for the same. Such claims are raised as afterthought. The certification of the respondent of the works carried out by the petitioner cannot ever remotely be construed as an admission of extra work by the petitioners. But this submission is completely contrary to, my lord, page 433 and 434 that I have shown to your lordship. They themselves contemporaneously call it to be an extra work, both in case of iron as well as in my case, but allows one, disallows the other. documents of the respondent of 2011 and 2015 describe it as an extra work. But in the affidavit in opposition, they say that this is not an extra work, this was part of the contract.
Mr. Dotto, they say
Yes,
para 28,
yes,
the last line from the bottom. The
Yes.
work carried out by the contractor was essential for the purpose of effective execution and completion work.
right.
And I deny that it can be termed
Termed as an extra. That is why they qualify it. Why it is not extra? Because it is part of the job. To that, my reply is 433 and 434.
yes, that extra work was part of the job. That is what they have said.
No, if it is extra work, may I say this, Milord? If it is, once you term it as an extra, then it goes beyond the contract. That is why it is extra work. If it is part of the contract, then it cannot be termed as extra work or additional work. Please have a look to relook to Milord, page 434 and 433.
Change proposal, তারপর change order হবে,
Yes.
change proposal.
Page 434,
Yes, please have a look to it, 434.
it says that they have approved the changed order.
Change order, change proposal.
Yes. Now, why this was required? Please come back to me at page 434. I'll explain why. First is the fifth line.
So the factum of this additional work which has been done, whether you term it as extra work or is an attribute for completion of the work, that is immaterial because they have also admitted that this work has been done. However, the work done by Mecon has been approved. Your case, it is not approved by the consultant, that project
Mecon.
management consultant Mecon.
Mecon. Now, at 434, your lords will find, my lords will find two things. The first is serial number 5, which says extra work.
Authorized price, extra work for yes.
Now, what is the extra works? There are two extra works. We are concerned about II, rock cutting.
Yes.
Now, please take the line, the last line over there, revised contract value rupees 109 crores. Now, why was this revision required? Because contract was for say 100 rupees. Extra work was say for 10 rupees. So in order to pay this extra work or the extra amount, 10 rupees, you have to revise the contract price from 100 rupees to 110 rupees. This revision of the contract value presupposes that it was an extra work. Apart from the user of the expression extra work, there is a revision of the contract price also. Because why will they pay ION extra if this was within the contract?
So, Mr. Dotto, why you are harping on that issue? Because the way you are explaining and the way they would explain, the ultimate conclusion is there was some additional work.
Right.
Whether it was an attribute of the main work or whether it is an extra work not coming with the contract is not, it is osseous because the argument which was advanced is that my partner has been given the amount for the extra work, you have denied it to me.
Milord,
This is the only
yes, Milord, my purpose is because of Milord, the statement made in paragraph 28 of the AO, where they deny that it can be termed as an extra work. Paragraph 28 of the AO, Milord, the third last line, they say that I deny that it is an extra work. Now, this affidavit in opposition is being filed on 14th of July 2022. Ignoring documents of 2011 and 2015 where they have accepted this to be an extra work and revised the contract price in respect of my consortium partner. Therefore, these argument, this affirmation at paragraph 28, which has also been supplemented in the supplementary affidavit by them, I'll come to that, is, Milord, contrary to the contemporaneous documents. And therefore, Milord, this submission or averment that it was not an extra work, Milord, in my very respectful submission, should not be accepted by the court, because the contemporaneous documents speak otherwise. And the respondents are saying that I don't have any contemporaneous claim, it is my afterthought claim.
That map which you showed us, that is what was the date of that?
I'll give you a lordship the date. It's 415.
Your junior will find.
2009. Where we-
2009.
Yes. 20th, one of the gentlemen have signed it on 20th of November 2009. The other gentleman's date is not available, 2009. And yes, other two signatures, the date is not available, but the year is available.
2009.
Yes. 20th of, and one of them has signed it on 20th of November 2009. Therefore, my lord, the fact that the work has been executed is not under dispute. Second is contemporaneous documents say, respondents' documents say it is an extra work. Now the question is, my lord, whether I am entitled to payment or not. Now, let us presume for argument's sake that it is not an extra work.
Then?
If it is not an extra work, my first submission would be, then, my lord, there was no requirement of revising the contract of ION. Because if they want to give me the payment today, they will have to revise my contract value also. Therefore, the fact that it was revised presupposes that it was an extra work.
Yes.
My lord, the contract conditions identical. Therefore, my lord, the same principle should apply in my case as also. Next, my lord, going by their documents, it is an extra work. Therefore, an argument can come that if it is an extra work, then it is, and if it is not part of the contract, under which law am I entitled to this payment? My lord, section 70 of the Contract Act is the answer.
Quantum media.
Quantum merit. আছে? Soft copy পেপারটা আমার জন্য। Don't get you, please.
Yes, you want to show us that section 70?
Yes, my lord.
Yes.
My lord, section 70, my lord, is part of chapter 5. Please look into the, my lord, the heading of chapter 5 before section 68.
Contract Act.
আমার কাছে চলে আসে দেখছি।
With your lordship, can you take my book, I'll find it out.
এইখানে আছে, ওকে ওকে ওকে, গট ইট।
Yes. We have the copy.
Yes. But please take me note the heading of chapter 5, just before section 68. Of certain relations resembling those created by contract. We are concerned about section 70. Please have a look to section 70. Obligation of persons enjoying benefit of non-gratuitous contract. This is a non-gratuitous contract with a commercial element involved in it. Money transactions are involved. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make a compensation to the former in respect of or to restore the thing so done or delivered. Then kindly take the illustrations. A tradesman leaves goods as B's house by mistake. B treats the goods as his own. He is bound to pay A for them. Then B, A saves B's property from fire. A is not entitled to compensation from B if the circumstances show that he intended to act gratuitously. Therefore, what is important is whether the contract or the activity, not contract, the activity is gratuitous in nature or non-gratuitous in nature. I buy so many things for my son. I do it gratuitously.
So, Mr. Dotto, what was we were as it was being argued, this section 70 is not, in your case, it is not. So now this amount of work, extra work which has been done by you, which has been allegedly found not tenable by Mecon, is it not a question of fact which has to be advanced on the basis of evidence? That you satisfy us.
Yes.
Because today the argument which we understood was this discrimination argument was
Is over. That is over.
As such, we told Mr. Gupta that can anything be done about this? Now he made his submission. Today, issue is dismissal was on disputed question. Now, how much extra work done? What was the measurement? What was the quantum? How can the writ court consider that?
But on that, my lord, my short and simple answer is,
or rather, stopping you for a moment, or you can show from page 433 that this rejection was expressly illegal. These 2 points you answer to us.
First is, my lord, page 409, my lord, your lordships, 415, your lordships were pleased to inquire, when was this document prepared and signed?
2009.
2009. No dispute on that. The next is 415 was annexed to Millard paragraph 11, to which the answer at paragraph 28 of the AO is whatever has been done for the purpose of the contract. Therefore, Millard, whatever is in page 415 is not denied, or the quantum of the work executed as per that chart at page 28, page 415 is not denied. This is number one.
Page 415.
In that map, big map, is not denied. Because 415 is an annexure to paragraph 11 of my stay application. Paragraph 11 of my stay application is answered in paragraph 28 of their affidavit in opposition, to which there is no denial. Therefore, page 415 is accepted, quantum of the work executed. No denial on that. Question is,
that is the map, Mr. Dotto. How can the quantum be ascertained from?
Yes, that is the quantum. That is the purpose of that map. Please have a relook to that big
Reservoir 1.
Reservoir 2 and Reservoir 1. The volume of the work which has been executed by me is on record, signed by the competent officers of Mecon and SAIL or ISCO.
All right. So your argument is quantity has been
accepted, recorded by them, certified by them, and accepted.
Very good.
Now, what do they say? They say that certificate is not an admission. This is what they say. But this is not my document, it is your document.
Where
Which is-
they have said that certification
Yes,
is
paragraph 28 of the AO, last sentence.
Certification of this one.
Mm.
Please check with the last sentence at page 8.
Yes.
The certification of the respondent of the work carried out by the petitioner cannot ever remotely be construed as an admission of extra work. But this was not required. They could have said that the certification is incorrect or no certification was made. They are trying to wriggle out of this by saying that certification is not admission. They are not disputing the certification. They are not disputing the quantum. They are not disputing the document. They are not disputing the signatures. This is how, my lord, they want to wriggle out by saying that a certificate is not an admission. I could have understood the certificate is disputed.
Yes.
Therefore, my lord, my very short case is, my lord, there is no dispute. I rely upon your document where you have recorded the quantum of the work. I rely upon your document of 2011 and 2015. You call it an extra work. I rely upon your document at page 434 where you have expressed it to be an extra work and have revised the contract value. Therefore, nothing remains. The learned single judge has dismissed the writ petition saying that it involves disputed questions of fact. But assuming for argument's sake, it involves disputed questions of fact, but there are umpteen number of decisions which say that yes, in the writ court also you can look into disputed questions of facts.
Now you explain this reason for rejection 433.
Yes. Now, reason for rejection is, so far as the work is, execution of the work is concerned, no dispute. 433 does not say that this is not an extra work. 433 only says that Mecon has not admitted this claim. That's all. Please have a look to me at 433 once more. Has not been, and the exact expression is, has not been made tenable by Mecon. Now, why? Well, there has to be some reason.
Now, this deviation committee also considered your claim.
Well,
The next line, Mr. Datta.
Deviation.
With reference, you are requested to attend the meeting.
Yes, this year Lordship will find from their supplementary affidavit.
You proceed in your manner.
Yes,
Then you come.
please have a look at this note. Yes. But I think that this 30th of, yes, this year Lordship will find page 16 of the supplementary affidavit at filed by the respondent on 14th February 2023. Affirmed on 14th February. The same expression has not been made tenable by Mecon. Paragraph 2 at page 16 of the supplementary affidavit.
The paragraph 2 is regarding to that first part A of page 433.
Yes.
Superfluous work of excavation.
No, the second, Miller, please take the second sentence, Miller. The first sentence at paragraph 2. Committee also intimated.
Second line.
Messrs.
The extra claim regarding rock cutting and disposal during excavation has not been
made tenable.
But then committee also informed the party that right now committee
that will not be discussed. Addition, rock cutting is not going to be discussed. Why? Because Mekon has not made it tenable.
Yes, yes.
So therefore, nothing extra was discussed or resolved, my lord, in the meeting of 30th of January 2015. So this was completely given a go by. Based on something which has not been found to be tenable by Mekon.
Where do you find that date, Mr. Dotto?
The date, my lord,
30th of January. Yes, yes, got it, got it.
after the names.
So now take us to the Mekon proposal, what the Mekon has said.
But Mekon proposal subject to correction is not possibly on record. Subject to correction by Mr. Gupta.
You're right.
Ache, ache.
No.
Mekon proposal is not with me nor on record.
কি করবে ওকে বলবে আনতে মেকন প্রপোজাল এক্সট্রা ওয়ার্ড কি এক্সট্রা ওয়ার্ড নয় কিছু হবে ওনার মনেও নিচ্ছে যে কাজটা হয়েছে কিন্তু আমরা কাজটা রিভাইজ প্রপোজাল দিচ্ছি না যেহেতু মেকন ওটা আনসুটেবল question of fact সেটা হচ্ছে whether untenability has been considered by a recent order. যদি কনসিডার করো তোমাকে ধরে নিতে হচ্ছে যে ডিসপিউট কিছু না এক্সট্রা ওয়ার্ড হয়নি এটা কেউ বলতে পারবে না হয়েছে ঠিক হয়েছে চলবো আমরা শেষ করে দিচ্ছি তুমি যদি কতটা কাজ করেছো না করেছো এইগুলো
আরেকটা হচ্ছে চেঞ্জ প্রপোজাল এন্ড চেঞ্জ অর্ডার
Yes, Mr. Yes.
Therefore, my lord, I my lord, kindly permit me to come before your lordship on some other days on two decisions. I have the citations with me, my lord, but my immediate junior is not in town, my lord. The judgments have not come. First is
Disputed question.
number one is disputed questions of fact. Number two, my lord, that celebrated decision of Radhakrishna Agarwal has been departed from by the Supreme Court by saying that Article 14 is applicable in contractual matters as well. But so long, my lord, most of the decisions were on the anvil that there is no application of Article 14 in a contractual matter. The third aspect is these are non-statutory contracts. So long, my lord, Supreme Court have said that in a non-statutory contract, you cannot come before the writ court. Again, my lord, the law has been changed by the Supreme Court saying that no, in case of non-statutory contract also, if one of the contracting party is the state cannot act arbitrarily. We are kindly note down the citations, my lord, so that Mr. Gupta can have a look to that. First is, my lord, in case of disputed questions of fact, writ petition maintainable. This is 2010, volume 11, Supreme Court cases, page 126. 2010, volume 11, Supreme Court cases, 186. Oh, I'm sorry, 186. I'm so sorry. 186. Paragraphs 25 and 28. Then, my lord, this is followed amongst others in 2021 SCC online SC 99 paragraph 46. আমি ইকুইভ্যালেন্ট সাইটেশনটা বলে দেবো আপনার। And Radhakrishna Agarwal, my lord, where, my lord, the Supreme Court has distinguished it that Article 14 is also applicable in case of contractual matters. This is 2020 SCC online SC 847 paragraphs 19 and 20.
19 and
20. And my lord, even in a non-statutory contract, my lord, the state cannot act arbitrarily, my lord. That is, I don't have the citation. MP power, my lord, your lordship must be having that. And on, my lord, section 70, my lord, the last decision is 2019, volume 5, Supreme Court cases 341. But here, my lord, the entire chapter 5 has been analyzed by Justice Nariman. Paragraphs 4, 6, and 7. Therefore, my case is very simple, my lord. If you say that it is part of the contract, then if you have revised the contract in respect of the other party, you should revise it for me. If you say it is not part of the contract, then, my lord, section 70 helps me. The court says, the learned single judge says it is a disputed questions of fact. In my very respectful submission, there is no disputed questions of facts which require adducing of evidence. But that is the exception. Mere disputed questions of fact, my lord, does not take away the jurisdiction of the court, writ court.
Then to ask you complete.
Well, give me 5 minutes on any other document only. I'll just place the citations. Otherwise, I finished.
Mr. Gupta, that you have already argued this Mekon resolution is with you.
Mekon resolution, no,
Resolution or decision.
Mekon decision is not with me, but the reference to that decision is there in on
From
page
deviation
433,
Page 430.
observation.
433 and
No,
34.
have you seen that, Mr. Gupta?
No, that's the Mekon is not possibly available with steel authority either.
It is not with them.
Possibly not with my client also. Possibly, I'm not sure. I can inquire into that.
So we fix it on a particular date. He has finished his argument. He will place those documents. And if you get the Mekon in the meantime, if you can show us that. When do we keep it, Mr. Gupta? Tell us.
But any day at 2 o'clock, my lord, I'll take maximum 5 minutes just to, and I will not add to the decisions.
12-13 রেখে
একটু লাগবে।
কারণ আমাদের চিকিৎসা হাসপাতাল। হ্যাঁ 12-13 বাদ দিয়ে যে কোনো
But I can come next week.
শোনো জয়ন্ত,
Next week এ রাখবো না? 12-13 রাখতে বারণ করছি।
14, 15, 16 any date.
My lord, any day subject to the convenience of the court after 13th.
Mr. Gupta, you
14, 15,
14th, 15th, 16th, any day, my lord, at 2 p.m. my lord, if your lordship's business permit. My lord.
original side আছে?
চিন্তা করা হয়েছে
So 15th 2 p.m.
Well,
15 June 2 p.m.
June.
We are not passing any order further. We keep it on 15th. Hardly learned that. Speaking parties. For fine. Under the same daily supplementary list of this court on 15th June as fixed at 2 p.m. Mr. Dotto, your junior has taken note of the judgments upon Mr. Gupta has relied. Have you taken them?
কোনো অসুবিধা হবে না, আপনি আছেন, আমার অসুবিধা।
Coming back to us.
Yes, madam.
I think he relied upon 2021 volume 10 SCC. Page 690, paragraphs 18 and 24. And 2021 volume 10 SCC 690 paras 18 and 24, and 2019 volume 5 SCC 192 paras 7.
দুটো জাজমেন্ট দিবি? তিনটে? But I believe two judgments have been relied. 2021 10 SCC 690 and 2019 5 SCC 192.
And Mr. Bose, on that time you are saying he showed us that 2007 volume 13 SCC 544.
ABL. Oh, ABL. But these are all considered in the first judgment that. Reference for this judgment.